And here we are once again. Welcome everybody. Good evening. This is Mark Emery with the Lighthouse Law Club. Glad to see you here with us. We have some powerful information to cover tonight. In fact, it's hard to describe how powerful this is, and you'll see soon enough as we get into it. Some of you have heard about the Lumpkin decision, and there's been a lot written about it. It's a current decision. It was still going on this year, and in fact, I think there's still activity on it in various ways, whether it be judicial or extrajudicial. And the party involved, an American living in Texas, was put upon by the federal government, which I'll explain. He is showing us all really how to fight back. You know, they pull tricks and dirty games and all kinds of things to obfuscate the truth, to confuse the issue, just all kinds of dirty tricks, as is typical in these type of scenarios in courtrooms, right? This Texan is teaching us all a lesson on how to take criminals to task. And I'll probably only be able to broach the key issues here tonight, and we'll probably need to continue with a further study of this, maybe in one or two subsequent sessions, because it's critically important, and it affects us all. It affects every one of us. And so what I've done is I've kind of gone through a lot of the updates and paperwork in the court, and I've kind of boiled it down to a presentation I'll share with you so that we can see the salient points without getting too bogged down in all the details. All right, so let's just go ahead and get started. So let's just start out right away and make a bold statement that the entire federal judiciary is a fraud, and we're going to prove it today. With this information, tomorrow, we all, Americans, need to be marching on Washington to take our country back. All of these crazy issues, you know, Black Lives Matters, George Soros, socialist activist groups, paid protesters, all this is nothing but a distraction from the key issue that our country has already been taken over. It's already been lost. And if we don't do something to take it back, we can just kiss it by. It's not an issue of, well, we could lose it. Well, if Trump doesn't do a good job and we don't stand behind him, we could lose our country. No, it's already lost. And you're going to see why here tonight. All right, I'm going to read some references from this website noted at the bottom of this slide, supremecourtcase.wordpress.com. Make a note of it. So today we're going to prove that all federal judges, magistrates, and all judicial officers are guilty of treason against the Constitution, bar none. None of them can get off the hook, and you'll see why. And the people who are responsible for this are not them, but Congress. Congress made all this happen. So we're going to accuse Congress of aggravated treason. What needs to be done is the American people need to present Congress with an ultimatum. Either fix this or be held responsible for the obvious charges and the penalties that go with that. It's up to us. And you know, it's amazing how God works in my life. Most of you probably are aware of the video I did, just published within the last week on the Montana Freemen. This was the entire point that they were trying to make. They had discovered many of these things, even though this particular case and its discovery still has not really concluded. It's just recent. But they were trying to tell us this back in the early 90s. And others before them were trying to tell us the same thing before that. Howard Freeman and many others, okay? But this case crystallizes what so many people have been saying for a long time. All right, so Congress is the one responsible. They need to be presented with a notice and demand or be held personally responsible. Even though those sitting in Congress were not the ones to initiate this in most cases, not all, but they have the responsibility. And once they've been notified of a crime, it's their responsibility to do something about it. All right, we're going to show tonight that all federal decisions since March 1st, 1991 are void. That's not to say that they're voidable, that one could go in and void it. No, they're void. They don't exist. And all the actors participating and who are involved in executing the orders are personally liable for damages. That would be not only the judges, the magistrates, the judicial officers, but the clerks, the bailiffs, process servers, the sheriff's deputies, executing arrest warrants and detention orders, and everybody on up and down the line. Now think about that for a minute. Think about how comprehensive that is. So we're going to talk about the Lumpkin Action at Law. This was done in the United States District Court for the Eastern District of Texas, Lumpkin Division, starting with Civil Action number 914-CV-138, referred to as the Lumpkin Action at Law. And it started out ready to foreclose on federal tax liens against the petitioner's ranch in Tyler County, Texas. All right, and the judge rules against him March 3rd of last year. So following the entry of a final judgment against the petitioner, United States Magistrate Judge Keith Giblin enters his order of sale and to vacate the property. That was on April 21st, 2016. At that time, the petitioner on June 13th serves an extrajudicial demand, notice, and warning of commercial grace on the judge. Many of you will recognize that as a substantive affidavit leading to potentially a commercial lien. All right? It's a commercial process, extrajudicial, outside the courtroom. All right, so this was served on the judge and two other federal judges and two United States Department of Justice attorneys involved in that particular case. So after 7 months of silence since his original order of sale and to vacate property, U.S. Magistrate Judge Keith Giblin enters his amended order of sale and to vacate property. Okay, so let me just finish out the bottom portion of our slide here. On September 15th, he demands the provision of the Constitution that gives the plaintiff, which is the United States, the capacity to take jurisdiction and enter judgments, orders, and decrees in favor of the United States, arising from a civil or criminal proceeding regarding a debt, which in this case was an alleged tax debt with tax liens, in the geographic area occupied by the body of Tyler County, Texas. This is where the Texans' real property was located and where the petitioner is a resident. Okay, so the counsel for the plaintiff, the United States of America, goes silent. He remains so for the duration of the case. He presented the court with questions they could not answer. And it's the custom of the Department of Justice, when they have been presented with something like that, they are to not affirm, not deny, and not respond. And so the entire court went silent. And some fun and games ensued from that. So let's look at the judicial power of the United States to get a little background on what was behind this case. All right? The judicial power reflects that certain constitution ordained and established September 17th, 1787, and implemented March 4th, 1789. Now we have to be specific, right? Because we know there are several constitutions that are referred to and designed to confuse and obfuscate law and reality. But the judicial power comes from Article 3, Section 1 of that Constitution. All right, and then if we look at Article 6 in Clause 3, this provides for the prevention of arbitrary exercise or abuse of the judicial power of the United States by way of a requirement that all justices and judges of the United States be bound by oath or affirmation to support the Constitution, right? Now that's not news, but it's important for us to understand the nexus by which the Constitution can require its support, enforcement, and execution. All right? And within the Constitution, it requires this oath or affirmation to support the Constitution. All right? And here's what it says. Quote, "The senators and representatives before mentioned and the members of the several state legislatures and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution." Now, that's pretty plain language, all right? You don't need a law degree to understand that. Simple. Anybody put into office to execute the laws of the United States must be bound by oath or affirmation. Simple, fair enough. So let's look at the justices and judges' oath of office. In Section 8, I quote, "And be it further enacted that the justices of the Supreme Court and the district judges, before they proceed to execute the duties of their respective offices, shall take the following oath or affirmation to wit." So here's the oath, right? "I, John Smith, do solemnly swear or affirm that I will administer justice without respect to persons and do equal right to the poor and to the rich, and that I will faithfully and impartially discharge and perform all the duties incumbent upon me as, for example, district judge, or whatever the title might be, according to the best of my abilities and understanding, agreeably to the Constitution and laws of the United States. So help me God." So what this is saying is that every officer is going to work to the best of their abilities, the best of their training, knowledge, and understanding, that their actions will be in agreement with and conforming to the principles and mandates of the Constitution and the laws of the United States. Of course, the laws of the United States are subject to the Constitution, which is the supreme law. So, that being the case, let's see what happened with that. Congress materially alters the oath. Okay, so what does Congress do? Congress, on December 1st, 1990, in Public Law 101-650 at Section 404, which you can find at 104 Stat 5124. That's Statutes at Large, for those of you who are not legal researchers. That's volume 104 of the Statutes at Large, page 5124. Okay, effective 90 days later, they alter materially by way of amendment the oath, which we just read, which is found at 28 U.S. Code Section 453, so as to relieve all the justices and judges of the United States of any duty of fidelity to the Constitution. Okay? Now, any of you who have been in court or who have been looking at these issues over the years, you've heard and seen many times where someone raises the issue of the Constitution and the judge says, if you mention that one more time, I'll have you thrown in jail for contempt. And you're just kind of scratching your head like, well, how can that be? All right, well, now you're finding out how it can be. The judges do not have duty or fidelity to the Constitution anymore. All right, and so we can go and look at that public law, Section 404. The section is titled Amendment to Oath of Justices and Judges. In Section 453 of Title 28, United States Code is amended by striking out, according to the best of my abilities and understanding, agreeably to, striking out those words and inserting under in its place. Okay? So now the oath reads, I do solemnly swear or affirm that I will administer justice without respect to persons and do equal right to the poor and to the rich, and that I will faithfully and impartially discharge and perform all duties incumbent upon me as, example, district judge, under the Constitution and the laws of the United States, so help me God. Okay, now, the average individual looking at that, reading that, would say, wow, well, that sounds pretty much the same, doesn't it? I mean, what's the big shakes there? Okay, let's look at that oath again visually for those of you who are online. We can see here where they took out those words, according to the best of my abilities and understanding, agreeably to the Constitution, and they just says, I, upon me, the duties incumbent upon me as district judge under the Constitution. So they're referring directly to the duties incumbent upon that official under the Constitution. All right? Not in agreement with the Constitution to the best of my abilities, but those duties incumbent upon me under the Constitution. Now here's why that is so important. We could say, but the only duties incumbent upon justices and judges of the United States to discharge or perform, those duties are only provided in the statutes created by Congress. Title 28, Judiciary, the laws of the United States. The Constitution doesn't provide any duties. It doesn't get down to the nitty-gritty. The Constitution stands on principles. It isn't a micromanagement document. So there are no duties for judicial officials outlined in the Constitution. Okay, so let's continue. The 1990 oath severs the connection between the federal judiciary and the Constitution. Meaning, as of March 1st, 1991, officers of the federal judiciary have no obligation to discharge or perform the duties of their respective offices, like it used to say, agreeably to the Constitution. Those words were written out, weren't they? And the former judicial branch officers are now legislative branch officers under the exclusive control of Congress. Let that sink in a little bit. What does that mean? That means that the independent judiciary is no longer independent. Congress merged the judicial branch of government into and under its own auspices. Is that sinking in? That's huge. Okay, now here's a Latin term. I'll give a prize to the first person who can pronounce it correctly. Plus peccat auctor quam actor, I think. Okay, which basically says the instigator of a crime is worse than he who perpetrates it. That comes out of Bouvier's Law Dictionary. And the instigators of the takeover of the federal courts of a limited jurisdiction by municipal judges masquerading as Article 3 judges from the Constitution, which they are not, and usurping exercise of general jurisdiction throughout the Union, those instigators are the members of Congress, who are the real culprits. Now, certainly the judges and judicial officials are co-conspirators. They're supporting actors. You know, they signed up to do a job and they took the oath that they were given. But they know full well what it meant, and they know full well what they're doing. So they're not acting without knowledge. So because there's no provision of the Constitution that requires a justice or a judge of the United States to discharge or perform any duties, there are no duties under the Constitution incumbent upon any such justice or judge to discharge or perform. So this is why in the Lumpkin Action, the U.S. attorney went silent for the duration of the case, 5.5 months. When the petitioner demanded the provision of the Constitution that gives the court, i.e. the judge, the capacity to take jurisdiction and enter judgment in Tyler County, Texas. So the petitioner was challenging jurisdiction. He was saying, show me your constitutional authority to take jurisdiction in this case. You're a federal court. You have limited jurisdiction. I'm in Texas. What are you doing on my territory? This is not federally owned land. It's not a dock. It's not an arsenal. It's not a territory. You have no constitutional authority. And neither the court nor the United States attorney was bound by oath or affirmation to support the Constitution. So you see now why they were silent for 5.5 months and failed to respond. So to prevent the fissure or the splintering of the federal judicial system, where we might have one set of justices and judges to discharge and perform their respective duties agreeably to the Constitution, like the old oath required, and then another group of judges and justices not doing that, what happened was between December 1st, 1990 and February 28th, 1991, all sitting and newly commissioned justices and judges of the United States take the new oath of office. Okay, so they get all the old guys to take the new oath, and then from that point in, everybody taking office thereafter would also then take the new oath. So everybody was on the same game plan. And no justice, no judge of the United States is bound by oath or affirmation to support the Constitution. Only the laws of the United States. Pretty sweet, huh? In the old days, they used to have wars to take over governments. In this case, they use lies, deception, and laws to take over the government. So let's just review the limited jurisdiction of the federal courts. I know most of you probably have had some exposure to this and understand this, but let's just review it. Let's kind of bone up on it a little bit. In the Supreme Court case of Rasul versus Bush, the Supreme Court said, quote, "As we have repeatedly said, federal courts are courts of limited jurisdiction. They possess only that power authorized by the Constitution and statute." All right. The Constitution is very clear on what power it extends to both the judiciary and the Congress, and it's very limited. All right, so this is why the petitioner in this case was so persistent. The justices and judges ensconced in the federal courts of limited jurisdiction are usurping exercise of territorial jurisdiction, which is an aspect of general jurisdiction, and they're entering judgment against the people. They're directing the disposition of their assets. They're committing theft under color of authority. That's Title 18, Section 241, denial of rights under color of law, federal crime. And in this case, they were doing all that to the petitioner's property in Montgomery and Tyler County, Texas, which is a geographic area in which Texas possesses the exclusive jurisdiction and sovereignty over the property located there. All right. So again, the Supreme Court tells us in Pennoyer versus Neff, quote, the several states of the Union are not, it is true, in every respect independent. Many of the right and powers which originally belonged to them being now vested in the government created by the Constitution, but except as restrained and limited by that instrument, the Constitution they're referring to, they, the states, possess and exercise the authority of independent states. And the principles of public law to which we have referred are applicable to them. One of these principles is that every state possesses exclusive jurisdiction and sovereignty over persons and property within its territory. Pretty simple and straightforward, isn't it? So if that's the case, confirmed by the Supreme Court, then what are federal courts doing forcing the sale and eviction of this guy in Texas off of his property in Texas? All right, so it's a clear conflict. And we're digging down to find out why and how that happens. Not just in this case, but in thousands of cases across the land. A couple more of the Supreme Court cases. Quote, those who framed the Constitution intended to establish a government complete for its own purposes, supreme within its sphere, and capable of acting by its own proper powers. They intended it to consist of three coordinate branches: legislative, executive, and judicial. In the construction of such a government, it is an obvious maxim that the judicial power should be competent to give efficacy to the constitutional laws of the legislature. Okay? In other words, the judicial power should lend credence and credibility to lawful legislation granted by the legislature, or to the contrary, make a notice thereof. All right, so we've got three independent branches of government. But because Congress enjoy only limited legislative power, which is subject matter legislative power only, which is to say that the subject matter they have the ability to rule over is outlined in the Constitution. Washington, D.C., the territories, military bases, docks, arsenals, and property owned by the federal government. That's the subject matter legislative authority that Congress has. Throughout the Union, very limited. And the federal courts and the Department of Justice are authorized to exercise only limited jurisdiction to that same subject matter throughout the Union, all right? And in that regard, the Supreme Court tells us, as we have repeatedly said, federal courts are courts of limited jurisdiction. They possess only that power authorized by the Constitution and subsequent lawful statutes. I'm inserting a few words there. So that's pretty clear. It doesn't take a genius to understand all that. Perhaps a little more study might be warranted for those of you that are interested in finding out exactly what that subject matter is, but refer to the Constitution, those articles 3 and 6 that we referred to earlier. So it's right there, front and center. Okay? So, looking ahead, what we have here is we have justices and judges who are ensconced in federal courts of limited jurisdiction. They are usurping the exercise of territorial jurisdiction, which is an aspect of general jurisdiction from the states. They're usurping state authority and assuming authority they don't have. And they're entering judgment against the people, directing the disposition of their assets, committing theft under color of authority. In this case, the petitioner's property, again, in Montgomery and Tyler County, Texas. So the Supreme Court tells us Quote, the several states of the Union are not, it is true in every respect, independent, many of the right and powers which originally belonged to them being now vested in the government created by the Constitution. But except as restrained and limited by that instrument, the Constitution, they possess and exercise the authority of independent states, and the principles of public law to which we have referred to are applicable to them. One of these principles is that every state possesses exclusive jurisdiction and sovereignty over persons and property within its territory. Okay? So again, it couldn't be any more clear. I mean, this is just black and white. It's good to review these to see how many times these points have been hammered home by the Supreme Court. And these are just a few. I mean, these are not, this is just a representation of the many references to these fundamental concepts which underlie the de jure government for the people of the United States of America. Okay? So we have justices and judges of the United States who have used their position of trust to betray their creators, the American people. They do that by overriding their own will in the Judiciary, the Bar Association, Congress, the corporation, their private will, the privateers for profit from the public. But they're overriding our will as declared at Article 6, Clause 3 of the Constitution, that all judicial officers of the United States shall be bound by oath or affirmation to support the Constitution. And so what they've done is they've legislated the Constitution out of the legal process. How do you like that? Supreme Court tells us if the Congress, as an instrumentality of sovereignty, is endowed with certain powers to be exerted on behalf of the people in the manner and with the effect the Constitution ordains, the Congress cannot invoke the sovereign power of the people to override their will as thus declared. So, a very serious situation developing here. It's very serious. Most of us are very well aware that the United States is a federal corporation. When it's referred to in many instances, of course, there are different legal definitions for the United States or the United States of America, depending on which body of law that you are looking at. Whenever you're doing legal research, you always have to look at the definitions in the front end of that section of law to find out what language they're using. You know, I've seen the same word used with 3 or 4 different definitions, so that if you don't check the definitions, you're thinking you're talking about the same thing in the previous body of law that you just read, but now you're in a different body of law and that has a different definition for the same word. So it's just all an artifice, sleight of hand that we can thank the Bar Association for. Okay, but just to verify that the United States referred to in this definition is a federal corporation and is no longer the de jure government that everyone thinks it is. Just look it up at 28 U.S.C. Section 3002, definition number 15. You can just copy that, put it in a search, and it'll come up. You'll see it. Whereas the United States of America is a sovereign republic, a de jure government created by and for the people through its Constitution. Okay. Interesting that notwithstanding that the federal courts are courts of limited jurisdiction, they are populated by municipal judges. That's what these judges are, sitting in federal district courts. They're municipal judges of the so-called United States, which is basically the District of Columbia Municipal Corporation. And these are the people who are usurping the exercise of general jurisdiction, which they do not have in Montgomery and Tyler County, Texas, and everywhere else in the Union of States. And so we've got a serious situation. As I mentioned, these guys have used their position to betray the trust of their creators, the American people, by overriding our will. And we can look down, I've already covered these first couple of paragraphs. Just to understand what treason is, here's how it's written in the U.S. Code, 18 U.S.C. Section 2381. Whoever owing allegiance to the United States levies war against them or adheres to their enemies, giving them aid and comfort within the United States or elsewhere, is guilty of treason and shall suffer death or shall be imprisoned not less than 5 years and fined under this title, but not less than $10,000, and shall be incapable of holding any office under the United States. Now, based on what we just talked about, we should probably go back to Title 18 of the U.S. Code and see what their definition of the United States is. But regardless, treason is treason. No matter how you slice it, the republic form of government has been conquered and no longer exists in the mainstream. There are groups trying to revive the republic, and more power to them. What we need to do, there's a number of different groups doing different things, and God bless them all. But what we need to do is we all need to come together, and we need to hold our public officials accountable to correct this criminal situation or face the consequences. And if you recall, if you were able to see the American Heroes, the Montana Freemen, you heard Dan Peterson talking about how they looked at the Declaration of Independence and they looked at their own state constitution for Montana. And in both of those, it's very clear that where to paraphrase, when a long train of abuses has driven the people to a certain point where they cannot tolerate it anymore, they have the right, not only the right, but also the duty to throw off that form of government and start over again. That's written right. As I said, this is what we need to do as Americans. All right, let's look at what does this mean to all the things that have gone on in the courtrooms. Okay, let's look at due process. What is due process? The essence of due process of law is the exercise of constitutional authority. Right? Denial of due process would be to deprive you of your rights and liberty, which includes property, without having constitutional authority. So what does that mean for all the cases and all the judgments, all the verdicts, all the orders issued by federal judges since 1990 who do not have an oath or affirmation to the Constitution for the United States of America? They have not executed due process, have they? And without due process, what we have is a void judgment. So it says here, again, Supreme Court in Hurtado versus California, quote, due process of law is process according to the law of the land. Due process of law in the latter, referring to the 5th Article of Amendment in the Constitution, refers to that law of the land which derives its authority from the legislative powers conferred upon Congress by the Constitution, exercised within the limits therein, and prescribed and interpreted according to the principles of the common law. Pretty straightforward, isn't it? So in any case where someone has been deprived of their rights, liberty, or property, without authority, that's a failure of due process, and that judgment is void. Any justice or judge of the United States who enters a decision or judgment in a federal case without the authority to exercise the judicial power of the United States, as outlined in Article 3, Section 1 of the Constitution, and this includes every Supreme Court decision and United States District Court judgment since March 1st, 1991, when they changed the oath. Any judge that does so without the authority of the Constitution and thereby denies the litigants due process of law, and he manufactures a void judgment. So what does that mean? That means that every judgment issued in federal court or related courts by judicial officers of the United States is void. It's not voidable. There's a difference between voidable and void, ab initio. So let's talk about that. A void judgment is an utter nullity and of no legal force or effect. And anyone who is concerned with the execution of a void judgment is considered in law as a trespasser. What they mean by anyone who is concerned, that means anybody who is involved to execute that, to support it, to bring it into force, to make it happen. Okay? So, as a trespasser, quote, a void judgment, which includes judgment entered by a court which lacks inherent power to enter the particular judgment, can be attacked at any time in any court, either directly or collaterally. Long versus Shorebank Development Corp. So, where a court has jurisdiction, again, quote, where a court has jurisdiction, it has a right to decide any question which occurs in the cause, and whether its decision be correct or otherwise. Its judgments, until reversed, are regarded as binding in every other court. We just saw that. Trump was bound by the 9th District Court's denial of his vetting law, travel ban, as people call it, until it was reversed by the Supreme Court. Now he can go ahead, but he had to honor that court's decision in the meantime, even though it was wrong. All right? But, there's a big but there, but if it acts without authority, its judgments and orders are regarded as nullities. They're not voidable, but simply void, and form no bar to a remedy sought in opposition to them, even prior to a reversal. They constitute no justification, and all persons concerned in executing such judgments or sentences are considered in law as trespassers. How do you treat trespassers? You tell them to stop trespassing or they're going to be liable for whatever damages they cause. Whether someone jumps into your yard and steals a garden hose, or someone trespasses upon your rights and throws you in jail unjustly. That's trespass. You have a right to be left alone and to exercise your rights, barring due process. Only due process can impose upon that. And since we now know district judges are not involved in due process, why? Because they don't have the authority based on the oath. So in Margolis versus Johns, this went to the Supreme Court, but the Supreme Court denied certiorari because they knew that the decision was correct, so they didn't hear the case. It says, we're just going to let this one stay because they're correct. And so in this case, in the Seventh Circuit, quote, a judgment is void if the court that rendered it acted in a manner inconsistent with due process. All right, now we understand due process. Do you have authority or don't you? If you don't have authority, you're violating my due process rights. Get out of my face. So for me, this was really a good review. I've known most of this before, but putting it all together, especially in the context of what we have in this particular case, it's extremely powerful, because the light bulb went on for me when I was reading through this, that this is the solution to our problem. Everybody's, trying to figure out how to go into these courts and come out alive, unscathed, and it just doesn't happen. The only way to win in a court situation is to stay out completely. If you go into that meat grinder, you're going to come out shredded. That's just the way it works. And so what we have here is we have clear proof that the Lumpkin case brought out that these federal district courts are violating due process every time they enter a judgment. Every time they issue a summons, they're violating due process. And Americans need to stand up against this and rally by the millions. And if we don't, it's up to us to correct this. We need to put enough pressure on Congress to correct this. They have that authority. They are the primary criminals for allowing it to stand. And why do they? Because most of them are members of the Bar Association to begin with. And this is the stranglehold that the Bar Association has put on the nation, the people of America. If we can get back to the courts, get some honest judgments, I'll tell you, that's why I left the country. I left the country in 1999 because I could see clearly that it was clearly a lawless state. Law is only to be used when it can enhance business for the District of Columbia Municipal Corporation. The law is copyrighted. And if you don't have permission to use the copyright, you can't use it. There's an organization in Chicago. I had a private conversation with Dan Peterson some time ago, and he said while he was in jail, he researched that, and in fact, he went to a local community legal help center, and the clerk there told him about that. He said, "Oh yeah, there's this group in Chicago. I'll bring this out in a future video, and they work on the uniform laws, making all the laws throughout the states uniform. And it's the only way to participate in this organization is you have to be a member of the bar. Okay, so you're not allowed to work for this organization if you're not a member of the bar. And so it works exclusively for the benefit of the Bar Association to establish uniform laws, and those are all copyrighted. In fact, he told me the story of a couple of people that actually wrote to them asking for permission to use the laws. And of course, they have to give it, because if they don't, then really the whole thing is exposed, and a lot of negative ramifications could come of that. So, all these things just all tie together. Our government has been taken over. It's been a silent coup d'etat, and we've got to do something about it. It's already lost. We've got to fight to get it back. Now, there's a lot more relating to this case, and I'm probably going to get into that in the next week or two to some degree. But we're already up on the first hour, and I don't want to drag this out too long. I think you've got the main points. But we'll pick up on this, and we will delve into this further.